All right, ladies and gentlemen, now we're going to talk about chapter 14. Of course, once again, we're in our textbook, Criminal Courts, Structure, Process, and Issues by Champion, Hartley, and Rabe. And I'm talking to you from, as a guide, the third edition, even though the official textbook for this class is the fourth at this point. So let's go ahead and jump into it. Chapter 14. So, chapter 14 is titled Courts, Media, and the Litigation Explosion. So, we finish up the book with a pretty interesting chapter. So, as an introduction, of course, courts have come a long way. I always talk about O.J. Simpson as the most famous case. That's what we're probably going to be talking about tonight. But there were famous cases well before the O.J. Simpson case. There was the Lindbergh baby case. There were a lot of famous court cases before the era of TV. So the O.J. Simpson was not the first case to be famous that everyone cared about, but it was definitely one of the first to really almost break TV. These days they talk about breaking the internet. I can honestly say that the O.J. Simpson case probably broke TV. It literally changed the way you watch soap operas. It interrupted my grandmama's stories, as they call them down south when the soap operas come on. It literally took over television. Matter of fact, I believe out of the O.J. Simpson case and its coverage, that kind of gave rise to channels and whole stations like Court TV, where you can focus on the trial and you can just cut it on and not interrupt everything else. So, trials in the court of public opinion, there's a difference. What you have to realize is in a criminal trial, there are rules of evidence that apply to what is admissible and what is not admissible. Then there's the court of public opinion. Now, public opinion, everything gets in, right? There's no hearsay rule, and I won't talk a whole bunch about the hearsay rule because that's a separate rule that you won't learn in this class. But it is a rule that keeps certain type of testimony out because of its unfairness. Um, but there are no rules of evidence in the court of public opinion. That means rumor, everything else can be out here. And you have all these pundits on CNN that may be legal. They may actually be, I guess, what I call the legal experts. But it doesn't mean they know what's in court or what's going on in court and what's going to be admissible and what evidence comes in. So a lot of times they're just talking heads. They're giving their opinion. They don't know what the jury has to look at to make their decision. And sometimes that's why. So as when you're used to listening to the court of public opinion, you get mad because you believe the outcome should be a certain way based upon what you heard in the court of public opinion, but it turns out 100% different. The outcome is different than what you thought it would be in the actual trial, and that's because you got to think in the trial. There are certain things that you can hear of in the court of public opinion that are totally inadmissible in a trial court. So a lot of the stuff that you hear in the rumors, those aren't a part of evidence. So that's not what the jury's using to make its decision. We talk about a brief history of the media in the courts. The media has always been involved in the court system, and this is before we get to TV media. Back in the day, before we had television, of course, you had the newspaper. Newspaper was very important. We didn't have any back in the day, well before my time. They didn't have television or internet, so you heard either on the radio or you heard via newspaper. Everyone wanted to know what was going on in the Lindbergh case. That's probably one of the earliest American famous court cases. I think there are some things earlier than that, but that I can recognize right offhand. The Charles Lindbergh case. So he was a famous aviator. He actually flied around the globe. And he was famous for that. He was famous worldwide. He was like an American hero. He was the closest thing. I'm trying to think who he was like the LeBron James of his time. So if you can imagine LeBron James going everywhere and being America's hero, that's who Charles Lindbergh was. But his baby was kidnapped in the night, stolen from from the nursery in the house. Someone climbed up a ladder, kidnapped the baby, and took the baby and held it for ransom. And this went on for months. So of course, all of America is looking for this baby. It's in the newspaper every day. then the baby winds up dead. So they find the baby, and then they're trying to link, they're trying to use evidence to link a person to the murder of the baby. So of course the ransom money was delivered, and it was a special type of money that they used. Like it was a special type of bill, so they could kind of keep track of who was spending it and stuff like that. So they ended up linking it to a person named Bruno Richard Haltman, or Richard Bruno Haltman. I can't remember the order of his first and middle name, but he ended up going to trial. So he was like America's villain. This person took, Charles Lindbergh's baby. He was a part of the murder and stuff like that. So went to trial, and it was, of course, it was all on TV. No, well, not TV then. I'm sorry. It was all in the newspapers, and everyone read about it every day because Lindbergh was America's hero, and his baby was kidnapped and murdered. So he had a trial. Now you look at documentaries about the case, and I don't know if it was necessarily the fairest trial, but it is what it is. He was convicted and executed. But that's an example of how the media can attach to court, and I think, and this is my opinion now, I think the media is so attached to what happens in court because the media is drawn to what's a good word, to disputes. Just think about in real life. If we hear two people arguing, what do? We don't walk away like they're arguing. We go, oh, what are they talking about? We go to it. It's something about human nature, and media is human nature. We are attracted to conflict. So and guess what the court system is? It's conflict. Literally, two sides don't get along, so now we're in court. So sometimes it just depends on who is in conflict, who the parties are. Or, especially when they're famous people, or when it's involving a famous person, that draws the media's attention. So that's why I believe the media is so fixated on court, and why there's such a marriage between media and the courtroom. But the current status, of course, is we have court TV, and now you have all these television stations and junkets that get to go right into court, and with court TV, you actually have a televised trial now. They actually have a TV station. It used to be on cable. It's not even on cable anymore. You can get it on a regular antenna. Like, we watch court TV in my office all the time. So literally, you can watch different trials. Now, they're not all famous people. They're trials you heard of, but they always give the trials a nickname, or the case a nickname, and you can watch a whole trial play out. So if people are court nerds like that, they can watch court TV all day. But the case that really gave rise to that was the O.J. Simpson case. Like I said before, it literally broke TV. It broke everything. It interrupted everything. From the time he had the slow speed chase on the interstate, or the freeway in Los Angeles, to the time Johnny Cochran said, "If it doesn't fit, you must acquit," and then they acquitted him. Then that whole window of time, literally, it took over. It took over the media, and I think it happened in the spring. As a matter of fact, I think the day of the low speed chase, I want to say that same day, Arnold Palmer, one of the greatest golfers on earth, he was playing his last Masters tournament. It was crazy. So there was stuff going on in sports. I want to say it was Aprilish or something like that. And so there was stuff going on in sports. I want to say the NBA was going, so they were in the playoffs. So it's not like nothing was going on, right? So but he literally broke TV. Like, a lot of people can't tell you who the NBA champion was that year. I can't remember. I think that might have been. I don't think that was during the Michael Jordan Bulls era. I think he had retired or something like that. I think that might have been one of the Houston Rockets wins, 2 wins or something like that. But people. The one reason we don't remember who some of those champions were is because instead of watching that, people were watching the O.J. Simpson trial. It took over everything. So now, one of the dangers of we talk about pretrial publicity. One thing about juries, that we select juries from the people, right? Me and you could easily be a juror, selected to be a juror. And before we're selected to be a juror, what? We're walking around, we're looking at TV, no different than the O.J. Simpson jurors were. They probably saw the low speed chase on TV because it interrupted what they had going on, just like it interrupted us, right? So they saw it. They saw everything unfold, and then all of a sudden you get a jury summons, and now you're asked to come to court, and you're selected to be a jury on this case. The danger of certain pretrial publicity is, now we want our jurors to be fair and impartial. We want them to forget everything that they learned about the case on the outside and just focus on what is in front of them. And that's kind of a hard sell, because as humans, we don't really forget you can't unsee something, right? When you make a decision, but we ask jurors to do that. So they saw the low speed chase, and then that, in my opinion, back then, I think I was probably like, when that happened, like 94, 95. I was like 13, 14, maybe something like that. But I looked at it, I was like, wow, OJ looks bad for him, because if you think about it, these jurors, there was a low speed chase, and this is before trial, right? So everybody saw him presumably running from the cops at 35 miles per hour, went very fast. But there was this whole situation, right? And everyone sees it. And, he looked guilty, not necessarily because of facts in the case, but because he was running. Why was he running, right? But that running is not necessarily evidence. There was still hard evidence that had to be presented at trial. So you have, in the O.J. Simpson case, you got a murder scene. You got all this stuff going on. You got, blood. You got, what was the crime? What was the weapon? Where was O.J. at? Alibi evidence. You got evidence about the two victims and all this stuff. Where did it happen at? Who witnessed it? Who was around that might have heard or might have seen something? All this comes into play, right? So all that stuff is relevant, and really the low speed chase really isn't relevant to whether or not he actually did it. So but in the court of public opinion, once again, not the criminal court, but the court of public opinion, it's like, whoa, OJ did that. Why was he running? He was, it's possibly he was running because he felt like they were going to accuse him of it. Just one of those situations. In my opinion, do I believe he did it? No, just because if you study the way the people were killed, I don't want to go into it, but it would have taken a professional to kill those people the way they killed them, and that was not, OJ was not a professional. So now, could he have known? Don't know. Possibly could have set it up, or could have been a murder for hire, but that definitely was not the handiwork of a old dried up football player with bad knees, attacking this young, very virile and strong martial artist named Ronald Goldman and Nicole Brown Simpson. I think he would have beat OJ's behind. So I don't think OJ would have been able to stab Ronald Goldman man to man. He would have got beat down. But that's the evidence. But you have to take the court of public opinion out, and you have to talk about the evidence, what makes sense and what is presented at trial. Two different things. So the danger of pretrial publicity is that the jury pool can now get tainted by the pundits, the people that really don't know what's going on. They can tell you about court because they're experts about court, but they don't get the evidence, right? They're not looking at everything, so they don't know what the jury has to base their decision on. And the jury, in a lot of situations, juries have a way more limited and way more narrow scope of evidence to make their decision on than the court of public opinion. The court of public opinion, we make our decisions on everything. What they're talking about at the barbershop, right? I think OJ did it, and they don't know. They're at the barbershop. You listen to a barber. He didn't even go to high school, right? He didn't finish high school. But you listen to the barber. You listen to all these dudes and this old man in the barbershop making your decision on whether or not he did it. Or it may even be based upon race or whatever, because it did create a racial divide in the nation. But the court of public opinion is making this decision based upon something else that is not relevant. In the court system, we make our decisions based upon what's relevant, what gets to come in the evidence, what's admissible and what's not admissible, because there are very strict rules of evidence that apply in a courtroom. We don't just get to walk in and have anyone say, I think he did it. No, we need evidence. Evidence via testimony and physical evidence is testified to, because physical evidence does not come into a trial unless it is testified to. Someone has to testify to the nature of what it is, chain of custody, how they're connecting that to whatever crime had taken place or is alleged to have taken place, right? So there's real evidentiary rules that apply in criminal court, the actual courtroom, but that don't apply in the court of public opinion. So the danger is what the court of public opinion is talking about, what's on TV, what the barbershop's talking about can now taint um, the jury pool, and it can now affect the jury pool's ability to be fair and impartial. So that's the danger with media in the courts, especially pre-trial. Usually once a trial starts, it's not as much of a danger, but it still can be a danger because guess what? These jurors have now been a panel, but guess what? They go home every day. When they go home every day, they got TVs, right? So a lot of times the judges try to sequester a jury, try to, even though they can't really do it that much in certain, extreme situations, they actually take the jury, they put the jurors up in hotels and stuff like that. That doesn't normally happen. I don't think it happened in the O.J. Simpson trial, but they do order them not to listen to TV, don't pay attention to any of that. They give them that warning that has nothing to do. You're here to actually look at real evidence, not what Nancy Grace says or a CNN pundit says. We're here to look at real evidence. So please do not pay them any mind. Let's focus on what's in court. As a matter of fact, being a juror gives you more of an advantage than the people on the outside because you see what's real. You have the real crime scene photos. You have the real, you have everything. So you're making a real decision. So it would actually be better if you didn't listen to CNN because they don't know what they're talking about. But you as a juror, you're there and you see the evidence. You do. Um, but there still is a danger that their ability to be fair and impartial can be tainted by, pretrial publicity. Um, so what could be prejudicial stuff? Now when it comes to prejudicial information that a potential juror is getting pre-trial that could affect his or her ability to be fair and impartial, what type of stuff can be prejudicial? Stuff about the life. Now we know. Of course, he wasn't convicted. He was acquitted, right? So he wasn't convicted, meaning he was found not guilty by the jury. But think about all the stuff that was put out there about OJ. And most of you guys aren't old enough, but there were things that were put out there about OJ that had nothing to do with the murder. They talked about his marriage with her. Which is kind of relevant, and it was an abusive marriage. And I'm not, OJ was definitely a jerk, right? But being a jerk doesn't have any relevance when it comes to whether or not he committed this murder. Maybe kind of to prove a motive, possibly. But yes, he was a jerk in that marriage. He was abusive. He was a butthole. But that doesn't mean he killed her in this situation. So, there was a lot of prejudicial stuff about his character and how he was in the marriage, and that gets into the jury's mind without it even being presented in evidence. Then now the jury's making a decision because OJ is a jerk because I heard on CNN he beat his wife, as opposed to the evidence, the actual physical and testimonial evidence in court. So you don't want that's the danger of certain prejudicial stuff, and stuff about a person's past can definitely be prejudicial, and it actually works both ways, not just with defendants, but also in victims of cases. You look at these rape cases, where now in the court of public opinion, if you think about any major rape case of let's say where a celebrity has been accused of rape, almost all the time the young lady's reputation it comes out in the court of public opinion, where it be the Mike Tyson rape case, Tupac, Kobe, so all this stuff can come out, and it's not just prejudicial about the defendant, but bad things can come out that are irrelevant to the case regarding the alleged victim. So it can kind of work both ways. So it's a double-edged sword. The media gives us information, but sometimes that information isn't all good information. Especially nowadays, because now you had there was an FCC rule that was changed. Like I want to say it was during I want to say during the Reagan administration back in the 80s or something, but that gave us opinionated TV and opinionated media. Back in the day of Walter Cronkite, your Ted Koppel, your Dan Rather, they were straightforward. They told you what it was. They told you what they looked at and what they saw. Now you get a lot of opinion. And even in sports TV, everything's about an opinion. So how much real information do we get from the media, whether it's about court or not? It can be about basketball, right? We listen to Stephen A. Smith or Shannon Sharp, skip, every day. That is all opinion. Now some of them are credible because they're close to close to sources and stuff like that. But still, for the most part, what we hear in the media every day is opinionated news. So imagine now in the jury in the jury pool in 2020, or in this century, now being in a situation where they have to be dependent on to be jurors, but they're going home, and now they're hearing opinion news, not even like bad news, like that's just inaccurate, but it's inaccurate and it's opinion. It's based upon how this person feels. So they're it's much more dangerous for a juror to be exposed, or there's much more possibility of a jury being exposed to prejudicial information now than probably ever. So that's the dangerous part. If it's a high profile case, it's in the news and stuff like that. You don't know what's going to come out there that can now affect the juror's opinion. Of course, courts try to minimize the effects of pretrial publicity by first limiting who can come into court, not allowing cameras in certain situations. Also, I guess limiting what the jurors are exposed to outside of court, ordering them not to, watch TV and stuff like that. And sometimes the judges can do that. Now, how they enforce it, I have no idea, but judges can try to do certain things to instill in the jurors that whatever happens out there doesn't matter. So the judge is very, very important when it comes to making sure that a jury pool isn't tainted by pretrial publicity. So the judge so even if the judge can't control what they watch and what they do and where they are outside of court, the judge can still chip away at them every day and make sure they know that whatever they heard before they got into court this morning, if it wasn't in court, it doesn't matter. So judges have a very important role in that. So the litigation explosion. Litigation has exploded because there's more access to the court system than there used to be back in the day. So you got to think, America is a very litigious. Litigious means they like to be in court. It's a very litigious society. They don't mind filing lawsuits, right? Especially with a lot of stardom of celebrities and stuff like that. A celebrity knocks your drink over in the club on accident, and now he got a lawsuit to pay for your Jordans, right? And you want $20 million because LeBron James knocked your drink over, and the wine spilled on your new 11s, and you want to be compensated. Them 11s cost $200, but you want $20 million, right? So you now have this litigious society, and there's been an explosion of litigation because people don't mind suing people, even if it's for petty stuff anymore. You got paternity lawsuits. You got tort lawsuits, and let's talk about what torts are. Let's follow the book first. The book is following the book. A tort is nothing more than a civil wrong. So it is essentially, and some criminal laws are also tort law, or can also be sued for on a civil end. Like going back to OJ. OJ was charged criminally for the murder of Nicole Brown Simpson and Ronald Goldman. So he had a criminal trial going on. Remember, in the criminal trial, the burden of proof was beyond a reasonable doubt. He won the criminal trial. He was acquitted. That means they couldn't prove his guilt beyond a reasonable doubt to 12 jurors. So he was acquitted, went home. But a lawsuit was filed. A civil lawsuit was filed for the same set of facts, but it was the civil lawsuit alleged wrongful death. In other words, due to the actions of OJ, his actions caused the death wrongfully of Nicole Brown Simpson and Ronald Goldman. So he was sued for the tort of wrongful death. And I'll tell you what a tort is. And tort spelled T-O-R-T. But he was sued in civil court. He was now sued. It was now a civil wrong that he was brought to court for. So for this civil wrong, it's a lower burden of proof. Remember, we talked about it early in the semester. Where the burden of proof is now by preponderance of the evidence. So that means mathematically more likely than not, or 51 to 49. So it's a very low burden. So of course, with the same type of evidence they used in the criminal trial, now they were using that evidence to prove that he was liable, not criminally liable, but he was civilly liable or responsible for the deaths. And of course, with that lower burden of proof, they had no problem at least jumping that hurdle. do I think that was right? No, but it was a lower burden. So with a burden of proof of 51 to 49, or by preponderance of the evidence, that's essentially a coin flip. So more likely than not, it's not a very high burden. So whether I think it was more likely than not that he was responsible for the deaths or not, the jury did, and they unanimously found him liable for the wrongful death of Nicole Brown Simpson and Ronald Goldman, and so they sued him civilly and won. The families did, and they won a big judgment, and that's actually what led him to being in jail recently. He just got out not too long ago, but because he had to liquidate all of his assets, his memorabilia and stuff like that. It was all auctioned off and sold, and his memorabilia, his Heisman trophies and stuff like that went everywhere, right? So, fast forward years later, he's now, because he's a Heisman Trophy winner and he's a narcissistic ex-football player, and he now wants to live the dream again. He wants his jersey. He wants his college jersey, his Heisman Trophy. He now looks into the mob and the underworld to try to get it back and to try to see what they can do to get his actual memorabilia back. He pays these guys. He works with these guys. Pays them a fee. They go in to get it for him. They get it, and they say, "Hey, we got it." And they say, "Nah, but we want more money." And OJ's like, "No, I paid you guys already. We had an agreement. I'm coming to get my stuff." Doesn't work out that way. OJ has security or armed person with him when they come in. End up being an argument. That armed person who's behind him, who he can't even see, pulls a gun. Um, and they essentially give him his stuff. OJ doesn't even know the gun is pulled. He's arguing with the guy, but he gets his stuff, goes out, and of course these guys who are career mobsters, I don't know why they call the cops, but they're criminals themselves. They call the cops, and now OJ gets charged with armed robbery because he didn't pull out a gun, but someone in his entourage and his security detail did. So that now leads to him being charged. So he gets charged with that, ends up getting convicted of that. Of course, it doesn't technically have anything to do with the murder case from back in the 90s, but I mean, the prosecutor's licking his chops at the opportunity to now convict OJ of something and put him in jail. So that's what happens. But that's kind of just OJ's life in and of itself. His situation can explain is a good means of explaining criminal versus civil. So let's talk about what a tort is. I've used the word a couple times. You guys need to know the book does have a definition, but let's read it. A tort. Torts are private or civil wrongs or injuries, other than breach of contract, for which the court will provide a remedy in the form of an action for damages, a violation of a duty imposed by law, existence of a legal duty to a plaintiff, breach of that duty, and damage that is a result. So a tort is also negligence. So it's either a civil wrong that's taken, or some type of a negligence or a failure to act or meet a duty that you're supposed to meet. So that is a tort. So now that you know what torts mean, now you know the difference between. Now that's why certain crimes, if committed, and there's a victim, that victim doesn't just have to take you to criminal court, or get where you're charged with a crime, and it's the people versus you, or the state and versus you. That person also has the right to file a lawsuit depending on what's going on, what type of case it is. So of course we have what we call industrial capitalism. So you have industry that's growing, and you have these industries that are growing. They want to make more money. They're greedy. They're doing things. They're cutting corners, and sometimes cutting corners in industry leads to consumers getting hurt. Because you failed to design a certain product the wrong way, a kid gets choked, or a consumer gets hurt. Now that consumer is like, I'm going to sue you because you could have designed it better. Because you failed to design it a certain way and you were negligent. Now the public is at danger. We want the product taken off the street, and I need to get paid. I need money for the damages I've suffered. So that's industrial capitalism is also giving rise to the judicial explosion. Um, and let me see, you got certain legislate. So then you also have uh, medical malpractice, and what that means. So another tort is medical negligence. When we talk about medical malpractice, we talk about medical negligence. So you go into the hospital, you're getting surgery, and the doctor makes a mistake. The doctor means well, doesn't mean to hurt you, but he fails to do something. He makes a mistake, and he's negligent, and now you got 3 eyeballs or something like that. But so now on the flip side, you're like, I can't walk around with 3 eyeballs. He got to pay me. So now you file a civil tort claim for medical malpractice. And yes, you deserve your money, but the problem is what happens in the medical industry is the medical industry as a whole, to practice medicine, you have to have coverage. You have to have what we call malpractice insurance. So that means now these premiums are going to go up for. So every time there's a med mal case, medical malpractice case, it drives up the price of premiums. And guess who now has to pay for that? So as a physician, I'm going to pass the cost of the expense of me having a medical practice. I'm going to pass that to the consumer. So the people that want to get medical treatment are now going to pay more because of a lawsuit, because of someone else's lawsuit. So it drives the cost. So it drives the cost of medicine up. So when you hear people talk about tort reform, that's one of the things they're talking about, trying to control or limit the amount that people can get in lawsuits when they sue physicians, or for medical malclaims, because it ends up driving the cost of medical needs up, right? So and it affects all of us, and that's why it's hard to get insurance. So that and it's crazy because you have to think about it from the medical malpractice victims standpoint. You've now been permanently injured because a doctor made a mistake. Now you got a short arm, or you got 8 toes or something like that, and your life is now affected. You do deserve to be compensated for that, right? Um, but on the flip side, you being compensated is now driving the cost of medical services up, because now the rest of the doctors that had nothing to do with you having a short arm or leg or a third eyeball, um, that now makes them practicing medicine and them having medical practices, it now drives their cost up, and that cost always gets passed to the consumer. So tort reform is one of those things they talk about when they talk about medical cost reform and the medical insurance crisis, with making sure everyone gets medically insured or is able to go get medical treatment if they need it. Getting some type of insurance card or something of that nature, whether it be the Affordable Care Act or whatever. Um, uh, Tort reform has something to do with that. So it's a fine line between making a person whole versus the cost going to everyone. So it's hard to make that argument unless it's hard to make the argument for tort reform, um, without having to consider that there's a person running around here with a third eyeball or a shortened arm, that someone's life has been changed forever because of a medical mistake, and they do deserve to get paid. They deserve to be made whole. So that's just one of the political things that goes into tort reform. So tort law is very important, especially when it comes to the medical side. Um, Let me see, so we talk about arguments for tort reform. Certain they're trying to lead to a increase in tort cases. Of course, a lot of times when these juries get these tort and these civil cases are now hearing these medical malpractice claims, they're giving out these huge multi-million-dollar awards, because like, wow, he got 3 eyeballs now. I couldn't imagine, man. That's worth $20 million. You know what I mean? So, but once again, that drives up the cost of medical treatment. So like I said, who benefits from tort reform? If we can reform and kind of limit, depending on what's going on, if we can limit these tort judgments, these medical malpractice judgment, who wins? And essentially, all of us win, because even though that one person is injured may not be able to get as much money. There's a limit to what he or she can get for the third eyeball or the messed up arm or the leg. But society as a whole, our medical prices are stay down. In other words, the cost is now no longer passed to us. And you got to think about it. There's no who else is going to pay for it. So if I'm a physician and now it's more expensive for me to run my medical practice. Who, when someone walks in, they're gonna pay for that. Like, for if so that means now my prices go up. So it just is what it is. So that's chapter 14. We're talking about courts, media, and the litigation explosion, including tort reform and what a tort is. So definitely read. Make sure you read chapter 14 to prepare. That is the end of the textbook for this semester. So you've gone through chapters 1 through 14 of the textbook. So definitely read and make sure you know everything, because the tests in this class literally come from the textbook. So if you've been reading, you should do well. So without further ado, you guys take care. Be blessed.